Hi, this is Attorney Mike Grevlin coming to you from Chicago as usual. And today I've got a really interesting one. I did a video yesterday and it was called Serious Hammer Crime. This one I'm going to call Hammer Time number 2, and we actually get resolution. I did this to follow it. I know you guys always like it when I give you the rest of the story. And in this circumstance, I can do it one day after the other. It's a criminal proceeding. It's a little out of my realm, but it's absolutely fascinating. Let's do it.
All right, we are on the record now in the matter of the people of the state of Michigan versus Dustin Jean LaHaraga. It is file number 20-19848-FH, file 20-19931-FH, file 20-19949-FH, and file 20-20008-FH. These are all set for pretrial hearings this morning, with the exception of the 20-19848 file. That would be set for sentencing this morning, but we've continued to keep that file together with the other ones. We are proceeding today by video conference. Video conference is being streamed to a YouTube channel in order to provide public access to the court's proceedings. First, let me ask the attorneys to place their appearances on the record, beginning with Mr. Hartung.
Thank you, Your Honor. Doug Hartung, appearing for the people today. We have no objection to the Zoom proceeding.
David I. Goldstein, appearing on behalf of the defendant in all the files. We have no objection to proceeding by Zoom, Your Honor.
Okay, and so Mr. Goldstein, where do we stand with these cases today?
Your Honor, there are a lot of moving parts that Mr. Hartung and I are trying to deal with. We have made some progress. There is a slight snag right now, which is that Mr. LaHaraga, prior to these cases, had a case in Jackson County, and they sort of ignored it for a period of time. But I have prodded them, and they are now moving forward. We want to try to get that case resolved before we can resolve these cases, and that should happen in the middle of January. So Mr. Hartung and I talked about maybe something early February. Is that right, Mr. Hartung?
That's fine. I have no objection to that, Your Honor.
Okay, how about February 9th at 8:15 a.m.?
Works for me, Judge.
That's fine.
And Mr. Goldstein, will you be willing to prepare stipulation and orders for those adjournments?
Yes, Your Honor. And I'll sign Mr. Hartung's name.
That's fine. Thank you.
All right, Dustin, I'll be in touch. Dustin, can you hear us?
Yeah.
I'll be in touch.
Okay. Is there a way to talk to you for a second? Real quick?
Not today. I can do it tomorrow.
Okay.
I got about 4 more Zooms I got to do today.
Okay.
Okay.
Yep.
Okay.
Thank you, Your Honor. Have a good holiday.
Yep. Thank you, Mr. Goldstein.
And Mr. Hartung, enjoy Florida.
Not going, but I wish I was. Thank you. Have
You're
a good
not?
holiday.
I thought you said you were going.
I was not going to go.
Okay, gotcha.
Your Honor, I see Mr. Daly's head there. Still, do we still have John Stover on the docket today?
We do. I think he is my last person in jail. So call and get Mr. Stover too, sir. So we'll call for him right now.
Thank you.
Stover for Judge Olsen, please.
Yeah, we were. Oh, I'm sorry. So he's. Okay, Ms. Underwood, are you ready for me to go on the record with Ms. Wagner's case?
Yes, I am, Your Honor.
We are on the record then in the matter of the people of the state of Michigan versus Tara Sue Wagner, file number 21-20598-FH.
Over.
Today is the date set for a pretrial conference in this matter. We are proceeding today by video conference. The video conference is being streamed to a YouTube channel in order to provide public access to the court's proceedings. First, let me ask the attorneys to place their appearances on the record. Mr. Hartung, are you handling this one?
It is not mine, but I could certainly sub in if we need somebody, Your Honor.
Okay. Like this is Mr. Fleming's case. Ms. Meir, are you there?
Yes.
Lee covers for you. No, I'm sorry, not you, Ms. Wagner. Phoebe, are you there?
Yes.
All right, I believe Phoebe Meir is probably covering for this. She's, I think, not in front of her device right now, so we'll give her a minute or two to see if she gets back to us. Okay, let me switch gears here for a moment while we wait for Ms. Meir and we'll move to. All right, if you give me just one moment, I need to step away for about 1 minute. I'll be right back.
Your Honor.
I'll be back in 1 minute, Mr. Stover. What do you need?
I was just gonna ask if I could confer with my lawyer before the proceedings begin in a breakout.
Yes, I can set up a breakout session for you with Mr. Daly.
Thank you, I really appreciate it.
Okay, Mr. Daly, are you ready to proceed with Mr. Stover?
I am.
We are on the record then in the matter of the people of the state of Michigan versus John Mitchell Stover, file number 21-20605-FC. Today's date set for a pretrial conference in this matter. We are proceeding today by video conference. That video conference is being streamed to a YouTube channel in order to provide public access to the court's proceedings. First, let me ask the attorneys to place their appearances on the record, beginning with Mr. Hartung for the people.
Thank you, Your Honor. Doug Hartung, appearing on behalf of the people. We have no objection today to the Zoom proceeding.
James Daly, appearing on behalf of the defendant, and we have no objection to the Zoom proceeding.
All right. Mr. Daly, then where do we stand with this case today?
There's been a plea bargain offer made, Your Honor. whereby if the defendant pleads guilty to great bodily harm less than murder, along with a sup, that there will be a killabrew that provides that he not receive more than 1 year in jail at the time of sentencing.
Wow.
Okay, and is Mr. Stover going to avail himself of that plea bargain?
He is.
Okay, Mr. Hartung, is that the people's, is that a full and accurate statement of the plea agreement?
Just a clarification, that would be a year in jail. We believe he would guideline out to a prison term, just so we know that. That's one of the reasons for the killabrew. 5 years of probation. The court does not have an amended information in front of it, I don't believe, although I've kind of been asking to get it produced. It would be a naturally lesser included offense of count 1 on this, so we can pause and get an amended info, or we can do it post plea, whatever the court prefers, but it is a naturally included offense of count 1.
It's an
Okay.
included offense of count 1?
I
So
would, I think I would prefer to have an amended information in the file. If, did you say you had already requested that?
I have requested it. I don't know if it's been produced. I'll follow up. I wasn't certain who was going to plead today until this point, but I can follow up.
Yeah, that's fine. I don't think we have it yet, but we can, we'll move forward as soon as we get that.
Okay, thank you. I'll get it rolling if it hasn't already.
Your Honor, I was requesting to speak to my lawyer before he tried to take off.
Okay, you would like to speak to Mr. Daly again?
Yeah, please and thank you, because I mean, I wasn't aware of the original charge being kept on there.
Okay, I think Mr. Daly can probably explain that to you. Let me.
Yeah, the original charge will not be kept on there, just so we know. That's part of the proposal.
So just what I'm understanding, Doug, is that you guys are going to amend it from the original set of charge at the top of the title, and you're going to amend it to, which is the 25 year?
Not exactly.
Okay.
Just record, we're talking on the record. An added count will occur on the information because you're already bound over on the earlier counts.
Correct.
The other will all be dismissed at your sentencing.
Correct. Okay, that's all I was trying to, so it's just going to be the great body.
That's correct.
All right, thank you.
You're welcome.
All right.
Okay, I do now have the amended information for Mr. Stover that includes 4, which is the assault with intent to do great bodily harm less than murder. So we can proceed that case. We are on the record now in the people of the state of Michigan versus John Mitchell Stover. We're on the record again today, file 21-20605-FC. And we're here for a pretrial conference today. Parties have previously put their plea agreement on the record, and I do now have an amended information that shows an added count 4, which is the assault with intent to do great bodily harm less than murder charge. Stover is going to be pleading to according to the agreement. Mr. Stover, would you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Will tell the truth, nothing but the truth, so help me God, I do not swear.
Okay, will you affirm?
I will.
Okay. Thank you. Then you are John Mitchell Stover, is that correct?
I am.
Mr. Stover, you've previously heard the statement of Mr. Daly and Mr. Hartung. Is it your intention to plead guilty today to count 4 on the amended information, assault with intent to do great bodily harm less than murder?
Yes.
Are you satisfied with Mr. Daly and the advice that he's given you?
I am.
Do you understand that the maximum penalty for this offense is 10 years in prison or a $5,000 fine?
I do.
Your Honor, I'm sorry, I'm going to interrupt this because I don't think the court caught Mr. Daly's comment earlier. There's also, you pleading to 1 sup in this matter, 1 habitual supplement, which would increase the potential high number to 15.
I think that's a little excessive, Doug.
I understand what you're saying.
No, that's definitely excessive.
So, Mr. Stover, do you understand that with the 1 supplement that you'd be pleading to, that would change the maximum potential penalty to up to 15 years in prison?
I do, and I'd also like the record to reflect, I was told probation would be 3 years, not 5. That was the agreement that I understood from the gates. I think 5 years is excessive as well, Doug.
We have our position on this right now, and the court can always change the probation down the road. That's fine with us. But as of right now, it's the great bodily harm, 1 sup, 5 years probation, Killebrew plea, not to exceed 1 year, initial jail term.
Understood. I just would like it to be understood that I intend to fulfill the probationary terms completely, and I just don't want to be held back from moving forward in my life once they're completed and the fines and everything are taken care of.
All right. And so, again, you understand, I appreciate your position, but you understand that the agreement is to the 5 years of probation at this point.
I do.
Okay. Other than, as we have discussed on the record here this morning, neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Mr. Hartung?
It is, Your Honor.
Mr. Davis?
It is, Your Honor.
Is that also your understanding, Mr. Stover?
Yes.
If a guilty plea is accepted, there will be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You can ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes.
And do you also understand that any appeal from the conviction and sentence pursuant to this plea would be by application for leave to appeal and not by right?
Yes.
If you are not a citizen of the United States of America, a conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights, Mr. Stover?
No.
And you understand you're giving those rights up?
Yes.
How do you wish to plead then to the charge that on or about June 28, 2021, in the city of Adrian, county of Lenawee, that you did commit the offense of assault with intent to do great bodily harm less than murder?
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to that charge?
No.
Do you understand that if I accept the plea, you will be giving up any and all claims that the plea was given as a result of threats or promises that were not disclosed to the court on the record here this morning, or that it was not your own choice to enter that plea?
I do.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce the defendant to plead guilty?
No, Your Honor.
No, Your Honor.
Mr. Stover, other than as we've discussed on the record here this morning, has your attorney promised you any particular sentence or estimated what your sentence would be?
Just, well, the estimated year, as far as I understand, other than that, no.
Is it your own choice to plead guilty today?
Yes.
All right, Mr. Daly, would you like to establish the factual basis?
Mr. Stover, is it true that on June 28th, 2021, in the city of Adrian, county of Lenawee, that you were involved in an altercation with Paige Young?
Yes.
And as a result of that altercation, did she suffer some serious injuries?
Yes.
And you are the one that was responsible for those injuries.
Yes.
I have no other questions, Your Honor.
Mr. Hartung, do you have any questions for Mr. Stover?
Very briefly, Mr. Stover, could you describe how you were responsible for those injuries? What did you do to cause those injuries?
The physical altercation itself was done by the act of hands.
You struck her,
Yes.
and you did so with the intent to cause great bodily harm, but not to kill her. Is that correct?
Yes.
I have no further questions, Your Honor. Thank you.
Thank you. I will accept the plea that has been given understandably, voluntarily, and accurately. Oh, I'm sorry, we didn't cover the supplemental. So he's going to plead to one offense then.
Yes, and it doesn't matter which one as far as we're concerned, Your Honor.
Mr. Stover, is it true that on December 1st, 2010, that you were convicted of controlled substance, possession of cocaine, heroin, or another narcotic of less than 25 grams here in the Lenawee County Circuit Court?
Well, with all due respect, Your Honor, I don't want to take a supplement on a 20-year charge. I think the lesser offense would be appropriate if we're going to use them.
Right.
It's not a clarification. Excuse me, right? By clarification, it doesn't double. It only increases it to 15, just so we know.
Well, I mean, I wouldn't know that. I haven't looked it up, so I couldn't say for sure. I just know that normally supplemental increases it to the, you know what I'm saying, half of whatever the original charge would be.
Doug, if you don't care, we've got a fleeing and eluding 4th degree that would qualify.
Yeah, that would work.
Okay. All right then. So then is it true, Mr. Stover, that on June 16, 2015, you were convicted of police officer fleeing or eluding 4th degree in the Circuit Court for Washtenaw County?
Yes.
All right. I will accept the plea then. It has been given understandably, voluntarily, and accurately. Mr. Stover has had full knowledge of his rights and he has had competent counsel. The court, other than as we have discussed on the record here this morning, has not made any other agreements regarding the possibility of a plea or possible sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them. I will refer this matter to the probation department for a pre-sentence investigation, and we will set sentencing for February 3rd at 8:15 a.m. Mr. Stover, someone from the probation department will be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about this offense and about your background. I will continue bond as it's currently set.
Your Honor, Mr. Stover wanted me to address the issue of bond. He understands that he still has some time remaining to do, but in the meantime, his mother is partially disabled and she is moving, and he's asked me to ask the court if he could have a bond until the time of sentencing. He understands that he'll be returned to confinement at that time, but he would like to get his quarters affair before that happens, and he's been here since June. Mr. Stover has a record of always showing up for court and being diligent in following the court orders. So based upon that, I would ask the court to consider a bond.
Mr. Hartung, do people have a position on that request?
We would oppose it at this time, unfortunately, but due to the severity of the injuries to the victim and basically the confirmed initial sentence, we don't believe that the bond would be appropriate at this point, Your Honor.
If I may, Your Honor, please. Mr. Hartung, I understand that you have opposements to this. This is my thing at the actuality. There's no way possible that I would ever do anything to infringe any type of environmental hazard on anyone or anything. And I wouldn't go out of my way to contact the alleged, the victim. And I wouldn't even be in this county. I would definitely return, but my mom is due to get her home and my sister's moving, and due to the corona, they all had it and they don't want to employ a moving company to come and do the work. and they need help moving all the physical assets and everything like that. And they're just not physically able. My sister can't move more than 5 pounds or she could risk breaking her neck. My mom is not physically able to do it. And I'm being honest, my sister was broadsided in an accident. So what I'm trying to say is, I understand if I have to come back here and complete the sentencing and all that stuff, I will do it and I will honor that. I will not run. The tail is ridiculously long. I mean, why would I consider it? I will be here on time. I will not delay. If I'm due to be locked up, you have my word. I will show up and finish the remainder. I have about 7 months in already. I have no intention of not honoring and fulfilling the probationary terms completely. And that's just my word to you. I'm not trying to escape my punishment in any way, shape, or form. I'm not going to run. I completed my terms of parole when I was on parole with no violations. I didn't miss one date to report, not one. I never dropped dirty, nothing. I have a job. I actually have 2 jobs, and I would like to just make a dent to try to help them get ahead. If I have to come back, at least I know they'll be okay. That's all I'm asking, sir, please. I will show up, Doug. I give you my word. And I will not contact the victim for the whole term of my probation or anything. You have my absolute word. I will not. I will not. And if I may, Your Honor, just to clarify, since I've been in this jail, I've stayed completely active. I've been an exceptional cleaner to help keep the facilities clean without any type of, anyone asking me if I want to. I take it upon myself to keep the blocks clean wherever I'm at. I try to look out for everybody in that regard to make sure their health is better. I'm an active person. I don't seek to do anything but other than just to do right. I'm honest about that. You can ask anyone to verify from here and they'll tell you I have the cleanest room and it's always in order. I'm serious about it.
Allow for Mr. Stover's release on a GPS tether. And the further conditions that you not use alcohol, marijuana, or any illegal controlled substance.
I did not see that coming.
Where will you be living, Mr. Stover? Do you have an address? All right, you can have a curfew of 6 p.m. to 6 a.m. that you have to be at that address.
Yes, sir. Will provisions be allotted for work or does it have to be within that time frame specifically?
If you have something from your employer showing that you need to be at work at a different time, I'll consider it, but unless I change the order, then it's going to be, you have to be at that address during those times.
Yes, sir.
Must not use or possess a firearm or any kind of dangerous weapon. Must have no contact with the victim in this case, in person, electronic, phone, written letter, no contact in any way.
You have my word.
As one judge here used to say, not even smoke signals.
Nothing at all, not third party, etc. Nothing.
All right. I want you to understand, Mr. Stover, also that if there's an issue with this and you violate in any way, that voids my obligation to abide by the terms of the sentencing agreement. And I don't have to give you the ability to withdraw your plea at that time. And you can be certain that I would exercise that right if there are issues with your compliance. I just want to be clear and upfront right from the start on that.
Your Honor, I have every intention to fulfill my probationary terms from now until the end of it. And I really appreciate the opportunity and the confidence that you're instilling in me to make the correct choices. And I do intend to follow up and not to let anyone down, including myself. I have a motto.
Right.
I lost a lot in life, but I'm not a loser. So I really appreciate your confidence.
All right. Do you have a working phone number where we can reach you?
Yes, you can message me or call me anytime, day or night. I will answer.
All right. With that, then we can conclude for today.
Wow. Well, there you have it. That was fascinating. I tried to do that earlier today, and I ended up doing a different video because it wasn't called, and then I had my own case. But this was fascinating in its own way. It's interesting to me. I'm not a criminal defense guy, but I could kind of see what's going on. Once again, James Daly pulled a miracle. He talked this guy into doing the right thing. It sounds like a great deal for him. And before everyone goes crazy and says the prosecutor was too lenient, you don't know the rest of the story. It's clear to me that the witness against him, the victim, didn't want to testify. Now, I don't know what their evidentiary basis was and how much they needed that. That may be a big deal. That may not be a big deal. But before you go judging about the plea offered, you got to know that a conviction may not have been easy. Yeah, I know what was alleged was pretty bad, but that doesn't mean you get a conviction. Or maybe it was easy and that's it, or maybe they just know that the sentencing guidelines it wouldn't be that much more. I don't know. It was fascinating to me. It looks like they did a deal where they can actually bind the judge. I think it's this Kilbrew case or something. I don't know. I don't do criminal defense, and I certainly don't do it in Michigan. But the judge at the end, and this fascinated me. Generally speaking, if you have a plea bargain, that what the prosecutor can say is, "I'll suggest to the judge to do this," but the judge doesn't have to follow it. It sounds like this case, and I'm just guessing here, I don't know. It sounds like this case is saying we can set up a deal where the judge is bound by it if he agrees at the time he takes the plea. That's what it seems to be. And as a result of that, he's doing that. Then the other thing that just absolutely fascinated me, shocked me, is that he lets him out on bond after this. So several things shocked me. I didn't think that James Daly was going to be able to get this done, but he did again. That's two very difficult cases in a row. I told you he was good. And I was surprised the judge let him out. But then I look at it and it looks like he's facing a year. I don't know if he's getting time served for waiting for this with a plea or if that's an additional year. I just don't know those things. I really could have used my friend Keith Stickley on this one, or Natalie Lawyercheck or something to help that stuff. But it was really interesting. The other thing is the defendant vacillated and he almost stepped off a couple times. But it's really strange. He's very, very aware of all of the stuff. He's obviously been through the system a bunch of times, and he's very sophisticated on one level. He's worried about the supplement and what difference that makes and all these other questions. But then he sort of says stuff that just shows he doesn't really have any sense about it, because all that was discussed and set forward. The prosecutor was honest, it's clear to me, because he just kept reiterating what he had already said. But in the end, it got done. He pled guilty. And, I don't know. I might take a look at his sentencing, but I doubt there will be anything interesting, because if this guy stays in line, then it looks like that we already know what the sentence is. That was also interesting to me. The judge admonishes him. He says, "Look, if you mess up when I put you on bond, I don't have to follow the sentencing deal. I can pull that and sentence you to whatever I want within the plea." All that is absolutely fascinating. Here at Law Talk, we like to have fun with silly stuff that happens in court, and every once in a while, and completely by accident, I assure you, you might learn something. Thanks for watching.